My Lord, we've placed on the bench then a draft declaration which I'll address the court on. Before I do that, it might just be convenient to finish the general submission.
Yes, absolutely. Do it later. We have actually had a chance to have a quick look at it because it was also emailed to us. We had a very helpful exercise, but in fact it doesn't, I suspect, on most points add to what your submissions are. So
no, it articulates in a 2-page document really what we say.
Yeah.
So maybe we could have said a 2-page skeleton argument, but there we are.
No, but anyway, thank you.
My Lord,
Yes.
In answer to the court's question as to what species of illegality is engaged by the policy complaints that we have.
The code.
The code, yes. So A is the authority, which will be familiar to my Lord, which is at tab 18 of the authorities bundle.
Yeah. We needn't write it down unless you want to.
No. Well,
but you say this falls within that.
Paragraph 46.
Well, shall we just have a quick look at it?
Yes.
I mean, this is the last word on the policy, isn't it?
Absolutely no. There's more recent articulation of examples. There's a decision of Mr. Justice Chamberlain in MXK, which we'll consider overnight whether that adds anything. But this, of course, is Supreme Court authority. And paragraph 46 on page 684. Refers to the 3 types of cases where policy may be found to be unlawful by reason of what it says or omits to say about the law when giving guidance for others.
Yes, absolutely. Well, that as the omitted to is really the point I was putting to you.
Yes, we would submit with a category 3 situation. It doesn't matter which category.
Sorry, paragraph 46, where are the 3 categories? Oh, at the top.
In broad terms, the paragraph begins.
Yeah.
Does the court have that?
Yes, I do have.
And then Roman 1, Roman 2, Roman 3. So here, because the Secretary of State is not under a duty to issue a policy, he has decided to promulgate one, and we say he has purported to provide a full account of the legal position but failed to achieve that because of an omission.
You say also, don't you, that there are positive misstatements?
Yeah, so it could also be one positive misstatement. It's, in a sense, has aspects of 1 and 3. So, my Lord, we do say there is positive misstatement. It matters not. We are squarely within the framework.
That's very helpful.
Primarily, then, we are concerned with the code of practice. We have referred in the skeleton argument to the absence of prosecutions. I accept it is difficult to read very much into that because it could be said, well, the industry is entirely compliant and that's why there are no prosecutions. We simply don't know, and I would acknowledge that. The trigger system is the 3rd aspect, which we say suffers from the same vice. So just slightly...
Well, the same vice, you mean the same difficulty as what one you've just identified about absence of prosecutions?
Yeah, it is formulated on a misunderstanding of the law. That is the vice. So if that is correct, a trigger system has been adopted which purports to identify breaches of the regulations, including paragraph 29, but the design of that system is based upon a misunderstanding of paragraph.
Are you going to show us where that's articulated in the paperwork relating to the system?
Yes, so if I can identify how this works then, please. So paragraph 15(2) or schedule 5A, so page 88 of the authorities bundle, of the, yes, the authorities bundle. So the system requires then a process for identifying poor animal welfare conditions, which must be communicated to the keepers and the Secretary of State.
Right.
We say that it must be inherent in the design of the system, which is known as the trigger system.
So just because this is at the slaughterhouse. This.
Yeah.
So what happens is at a slaughterhouse, there's always a vet in. You have to tell. It's probably in the evidence somewhere, but I haven't internalised it. There's always a vet.
Yeah.
At the slaughterhouse.
Yes. Yeah.
And part of their job is to check that animals arriving for slaughter, in this case chickens, are all alive and healthy.
Yeah.
And if any is dead, they will spot it.
Yes.
And carry out a post-mortem.
Broadly speaking, that is how it's intended to work. However, the trigger system...
So someone is telling you from behind that you got it wrong.
Yeah. So it's a post-mortem assessment then, which then feeds into the trigger system. So the post-mortem assessment is conducted, and that will or will not trigger the report.
Sorry, that will or will not trigger?
Yes.
I see, because if there's
one,
nothing surprising, it just something happened to it in transit or whatever.
Yeah.
But if there is something that's indicative of poor welfare conditions at the point of origin, is that what they're looking for?
Yes, indeed. So if, for example, quantities are such as to indicate the adverse welfare conditions, then that...
Quantities, did you say?
Well, large numbers of mortalities, for example.
What about just one?
Well...
one, provided it is indicative of poor welfare conditions.
No, because it's essentially premised upon thresholds, of which mortality rates is one of those thresholds. So a single dead chicken will not ordinarily trigger that. Otherwise, because there will be mortalities, that is accepted. It has to be at a sufficient level to indicate the adverse conditions. So there are 2 points. So the first is essentially the direct linkage to paragraph 29, insofar as the Secretary of State does not perceive there to be anything objectionable in industry because of his approach to paragraph 29, namely he does not recognise the existence of any practice or any breeds that are going to violate paragraph 29. We say it is inherent then that in formulating the trigger system, the Secretary of State will have misdirected himself.
But this is the trigger system.
Yes, but in formulating how it works in practice.
No, sorry, I'm sure it's my fault. I clearly haven't digested. I thought you could just give me what you're showing us so far is simply the reg.
Yes.
Doesn't seem to be anything wrong in law in the reg.
Yes.
But you say, but that's only the first stage. That's what triggers the trigger system or brings the. And what I haven't understood is what documents encapsulate the trigger system, so we can see whether they include a misdirection.
Yes, I apologise. I've taken this too quickly. So
just before we go there, the regulation, while we're still on that, talks about the results being consistent with poor animal welfare conditions.
Yes.
But I thought it was your point that the problems arising because of the choice of breed have nothing to do with the conditions, they're to do with the choice of breed.
Indeed. So
how does this have anything to do with the choice of breed point that we're concerned with?
It is a bolt-on in the sense that our primary fundamental objection is paragraph 29 and the arguments that I have made. Criticism in terms of what the consequences are of the Secretary of State's erroneous approach are, first of all, code of practice, second, approach to prosecutions, and third, what we understand to be the formulation of a trigger system which is designed to identify adverse animal welfare conditions.
But if the vet were to conclude, well, there's a lot of dead chickens in dispatch, but it's nothing to do with the conditions they're kept in. It's because they've all had heart attacks because they're fast-growing chickens.
Yes.
That wouldn't, under this paragraph, require him to do anything or report to the Secretary of State.
No, noted.
You'd have to derive that from somewhere else.
Is that right? Well, sorry, just to play devil's advocate for a moment. Is that right in the sense that paragraph 29 is in a schedule which is entitled General Conditions under which farmed animals must be kept, so it's sort of at least notionally treated. You see that on page 79.
Yeah.
I mean, is it in essence it's treated for the purposes? I mean, there's no definition of the expression poor animal welfare conditions, is there anywhere?
No.
So it could be, in fact, encompassing
a
breach of paragraph 29, albeit that we do, I think your primary, I mean, my Lord's picking up with you, your primary point is paragraph 29 is about selection, not husbandry, or stockmanship, I think it's called. But I wonder whether, in fact, it would be capable of being used to detect a breach of paragraph 29.
Yes, we would say so.
I would have just to spell it out with my own thinking. You would have to adopt a purposive construction under which poor welfare conditions was really a paraphrase for any situation prohibited by or any breach of the obligations in Part 2.
Yes, we understand it is interpreted by the Secretary of State in that way.
All right, but if this is going to be the big judgment about all this, it's a question of what it means and how it ought to be construed rather than what the Secretary of State says.
Correct, but in terms of the judgment, our principal complaint is that this is one of the three clear manifestations of why this matters in terms of the real world.
Can I just, pick you up on that? I may as well do it now.
Yeah.
I just want to see how these consequences fit into the judgment that you would like us to produce.
Yeah.
I'm not sure we need to be persuaded that a wrong construction of paragraph 29 would have consequences.
No.
Of quite apart from the code of practice, perhaps this prosecution's trigger system might be, but that's really strictly speaking unnecessary. We got to decide the point anyway because it's come before us.
Yes.
Are you actually asking us to make any particular order about the trigger system or declaration about the trigger system? Or would it not be enough for us to say, if you persuaded us to say it, Para 29 means this. It doesn't look as though the Secretary of State understands that. See the code of practice, see everything she's argued in these proceedings. That means that it's reasonable to assume that she's misdirected herself in the trigger system. She must go away and look at that, as well as the code of practice. In other words, we're not being required to make any detailed findings about the trigger system, or are we?
Detailed findings, no. So,
well, all right, or any positive finding that he has in fact set up a trigger system that fails to comply. If all we're being asked to do is declare the law or say that she seems to approach all her responsibilities in this field on the basis of misconception of the law, and we expect her to look at everything again.
yes. I'm just looking back at the relief sought. So part of the various declarations.
Are you looking at the claim form or the appellant's
form.
notice?
No, statement of facts and grounds. I'm conscious that, as I hope I've emphasised, we are very anxious that the court corrects the issue on paragraph 29.
Yes.
It is right, though, that we have pleaded the declaration amongst.
Sorry, which is right to say that what?
So 206 of the core bundle. perhaps if I can take this in stages, if I may. And this will also, to some extent, deal with the Secretary of State's objections on the pleading. So the grounds of challenge appear at 190. So first of all, we say unlawful policy permitting the keeping of breeds by reference to code of practice. 53A, misdirection. And 1A is what we refer to as the true interpretation of paragraph 29, so paragraph 193. And the 53D was the basis of the more reasoned declaration that we put before the court just now. Then,
sorry, 53.
53D is sort of an earlier version of what we've given to the court in terms of what we say the statute in fact means. And 1B, the code of practice is unlawful for reasons that we've been. Then Thameside, I would accept, goes hand in hand with everything else so far. I'm not proposing to say anything about ground 5, about a Thameside failure.
Sorry, I was just making a note. Where have you got to?
So ground 1C, which is 196.
Right.
Then we have a ground 2, which was and is an independent ground that the trigger system is operating in a fashion which inherently is not going to detect the necessary issue, i.e. the relevant detriments.
Yes, I see this.
And the basis then, articulated then, it is that we say it is operating at a threshold which is so far above any realistic basis for identifying a welfare concern that it is unlawful.
So threshold's too high?
Yes. And the judge says, well, quintessentially a matter of judgment by reference to the scientific evidence. And we say, well, the judgment has to be based upon factually correct premise, a factually correct premise. The most striking point that we make is that it must be based on paragraph 29 as a fundamental part of the welfare regime here. And insofar as the Secretary of State has erred there, it follows that he has erred in the setting or calibration of the trigger system. That must follow. The Secretary of State will say, well, it doesn't. So if they are wrong about their interpretation of paragraph 29, how does the trigger system nevertheless pass muster? We say it cannot. But we do and have advanced the contention that the methodology is such that it's simply not ever going to detect the animal welfare concerns in a sufficiently reliable quantity. And that is revealed by what has now been brought to our attention, which is essentially the ADAS report, which is the subject of the application. It says, well, look, we're going to do it again on a new basis.
Yeah.
Now, I would accept what I anticipate the court would say, well, this is a new point, in a sense, from the Secretary of State, and therefore this court shouldn't be intervening on a matter which is out for consultation, which it is. So I'm not proposing then to overstate this point. It is out for consultation, and therefore one would expect that the correct statement of the law by this court will be a material consideration on the part of the Secretary of State when finalising that consultation or its response to the consultation.
Sorry, can I just pause for a second? I'm sorry, I've lost the thread of your response to the original question.
I'm so sorry.
I thought you were asked, what are you asking us to do about
Yes.
it? And you started off by pointing us to the pleading, which then you sort of stopped, or maybe I missed it, but in the prayer for relief, it culminates in a request for a declaration that the system detecting, reporting, and monitoring welfare concerns in broiler breeds is unlawful. Okay. And then in your notice of appeal, there is similarly a declaration sought.
Yeah.
And are you saying that actually you don't want those?
No, we do. So it is unlawful because it is based on the same error.
Well,
So-
this is where I thought you were going, but I was wondering where to get there. Sorry, that was ruder than I meant. Now, all you want is a ruling on the meaning of para 29, and it need be no more than a paragraph saying, since it is clear that the trigger system must be premised on the Secretary of State's erroneous reading of para 29, it will need to be reconsidered in the light of the correct interpretation of para 29, and leave it at there. We don't need to say anything about thresholds. We don't need to say anything about all the detail that appears in the grounds and the evidence supporting it. And that seems to be a perfectly rational position. But if that is your position, there's very little more you need to say about the trigger system.
That is. So the declaration, it is right that that is what is asked for. Do we need that? If the court's judgment were to say that, we probably do not need a formal declaration which encapsulates that, because we would...
Well, that's also true, but we went on to the whether you'd have a declaration point. That's the point, not whether it's just in the judgment or whether it's in the declaration. The point we're on is whether we need to investigate anything else that might be said to be wrong with the trigger system, or put it the same, similar but not necessarily quite the same point, all the ways in which the misinterpretation of para 29 might have distorted the trigger system. Speaking for myself, either we will have to be taken quite carefully through the details of the trigger system in order to see exactly where the misinterpretation might bite, or you simply eschew that exercise and say it doesn't matter. All, subject to Mr. Turney may say, all that matters is if we win on the para 29 point, the trigger system will have to be looked at again, which, as it happens, it's been looked at again for another reason. But are you content with the latter?
Yes, absolutely, we are.
Yeah.
So,
well, in that case, the number of interesting questions I might have asked about exactly how the trigger system works are beside the point, and I won't ask them.
my lord, that only leaves then the draft declaration.
You can do it. You can do it.
I'm not quite sure why. I think it's why.
Yeah.
Does actually necessarily mean there's something wrong with the trigger system.
Yeah.
I can't quite join the dots.
Richard wants to ask one more question. Yeah, well, perhaps I can ask the question, my lord's question really, but I understand it and share it to some extent. We'd just like to have it spelt out why the various error, the central error that you have identified in the Secretary of State's construction of para 29 necessarily means that the trigger system as set up is wrong in law or fails to detect breaches of para 29.
Yes, the slight difficulty we have, and I'm certainly not avoiding this question, I'll answer it, is that it to some extent requires the Secretary of State to confront the point and say, well, it is nevertheless fit for purpose, even if we're right about the interpretation, for the following reasons. And the Secretary of State has not done that. So we understand it to be essentially linked, and it has to be linked. But it might be a point then that if I may address, having heard what the Secretary of State says, because if the Secretary of State concedes that, then there's very little, if anything, left to say. But as matters stand, we would say it's a matter for the Secretary of State to say one way or another whether they say it is premised on their interpretation of paragraph 29 or not, or whether it's completely independent. I appreciate it is slightly unsatisfactory not to immediately answer the court's question, but I suspect you'll be better informed if we approach it in that fashion.
Well, except if they say they agree it, then you're not going to respond.
Yeah.
And so I'll be none the wiser, or we'll be none the wiser.
Well, if I've understood the position I was urging on you, that perhaps doesn't matter too much, because what we would effectively be saying is we haven't had the workings of the trigger system explained to us in detail.
Yeah.
And it hasn't therefore been identified to us by either party where the interpretation of Para 29 affects the way the trigger system works.
Yes.
But it is enough that we say that the Secretary of State should now consider whether our reinterpretation or our correct interpretation of Para 29 does affect the trigger system. If she comes back and says, right, even accepting the court's new interpretation, assuming the court's now correct interpretation of Para 29, it doesn't make any difference to how we operate the trigger system, well, you'll have to look at her reasons for saying that. And if you really don't believe them, you have to go back to and bring fresh proceedings, which no one probably want to do. But in a sense, that's inherent in the way you've approached this generally, which is get the point of principle argued, and then hopefully the Secretary of State will change the system in a way that we're happy with. And if we don't, we'll have to come back in the second round.
Yeah.
And this would just be another element of that.
Correct.
I think.
Let it run for now.
Probably heard that. Let it run for now. If we find we're not satisfied with it, we may come back to you tomorrow.
No, I understand, and that's fine, and we'll give it some further thought, but that is essentially the point. So that's how we advance it. The court's indicated it's had a short opportunity to look at the draft declaration, which we say takes then paragraph 29, doesn't simply say it means what it says. What we've sought to identify are each of the constituent elements, and we therefore invite the Secretary of State to say which he agrees with and which he disagrees with. I certainly haven't.
Well, whether it's I think there may be a debate about whether it's appropriate to have a declaration looking like this. My immediate reaction is that these are the sorts of points that are better explained properly in a judgment, and then if you have a declaration at all, it will only say see our judgment, which is pointless. But that doesn't mean it's not useful. It's basically a checklist of the points that you have mostly now made, probably all now made. Yep.
Unless I can assist the court.
Right. Sorry, I should have said thank you, Mr. Brown.
Thank you.
My Lords, I was going to start by saying that my learned friend Mr. Fulbrook was going to deal with grounds 4 and 5 of the appeal, which was the trigger system and the tame side point. I don't think the tame side point's pursued. The trigger system seems to be a fairly narrow issue, so I'll see where I get to, and I may then have to hand over to Mr. Fulbrook to.
Yes, it sounds like there may not be much for him.
That's it.
To say, but you may.
Or you of his submissions.
Sorry?
I don't want to deprive him or deprive you of his submissions, but I might not need to do it. But anyway,
Let's see where we are with that. Yep.
So, can I start by just explaining the basic factual position that the Secretary of State has got to, having considered all of the evidence that's relied upon by the claimant and indeed by others in respect of the welfare of fast-growing breeds, and that is that those breeds of chicken can be kept without detriment to their welfare, health or welfare, I should say. And
Is there a report that says that?
I'll show the court that. It's not a report, but it's explained in the witness evidence to explain the position that's got to. And
Anyway, but the proposition is, one, fast-growing breeds can be kept without detriment to their health and welfare. Yep.
yes, that's the starting proposition, and that is so having considered all of the evidence, including, for instance, the RSPCA report, which I'll say a little bit more about in a moment. And that's so not in some sort of abstract exercise of considering perfect conditions for keeping a particular chicken, but in the real world of the way in which those chickens are kept. And I made that point at the outset because although, when I come to the construction of paragraph 29, I will say that it is not concerned with the conditions in which an animal is kept. Nonetheless, on this question, whether fast-growing breeds can be kept without detriment, the Secretary of State's answer is that they can be, including in modern commercial farming conditions. Now, the reason...
Sorry, just so I can be quite clear what you're saying, you made the point about they can be kept that way in the real world, but you're just saying actually that's not legally necessary as part of the definition.
That's not what paragraph 29 is about, although it's obviously something that the Secretary of State is deeply concerned with, because
Yes.
welfare of farmed animals, and in particular welfare of fast-growing chicken breeds, is high up, and has been high up the agenda within the department for many years. And the court will see that because this case is a case in point. The claimant has been engaging with the Secretary of State for many years on this particular issue. There's been to and fro, you'll see there's meeting minutes and so on over the course of many years, as has the RSPCA. So this isn't a point that's been left to a sort of narrow consideration of statutory construction. It is a real world question of whether the conditions in which this vast number of chickens are kept are acceptable or not in welfare terms. And that's a real world question that the Secretary of State's grappled with.
Can I just, before you go on, because did I write your submission down correctly or not? Did you say that paragraph 29 is not concerned with the conditions in which chickens can be kept?
No, it's not. I say it's not concerned with conditions, it's concerned with the identity of the breed. It's concerned with the breed.
Okay, I understand, right.
Yes. The court will see this position.
So just to that extent, I mean, in a sense, you agree with the first proposition. It's the sort of selection or choice, whatever you describe it. So, in a sense, 2.1 of the declarations that you were provided with is something that you agree with. I mean, you might phrase it slightly differently, whether it's choice, selection, or identity, or something.
Yes.
But it's broadly the same point.
Yes, I don't quibble with that proposition. It's concerned with the choice of the farmer as to which breed of animal is to be kept.
Okay, thank you. Yes, sorry, but you were helpfully summarising the where the Secretary of State has got to, as you put it, as regards the welfare of fast-growing breeds. I wrote that down as point one, but maybe that is the only point. Or were you going to make some other points?
I will in a moment. But might I just take the court to the relevant references?
I see these are the references making good the proposition you just did.
Making good that proposition.
Yep, fine.
As I was asked. And it's in the supplementary bundle. And it's a witness statement starting at page 88 of the supplementary bundle. The first witness statement of Pamela Thompson.
Yep.
I'm hesitating for a moment because below I asked that the judge read the whole of that statement, which is thorough and fairly lengthy as a result. I don't think the court needs to read all of it. but it is it sets out in some detail the process that the Secretary of State has gone through on this issue, and it also explains in some detail the various controls on welfare and how they work in practice. So it may be a helpful reference point. The critical part for the submission I just made is at page 115 and following. And the heading of section D gives away the answer. Fast-growing breeds of meat chickens can be kept without detriment to welfare. And that's the proposition that Ms. Thompson then goes on to explain. She, in particular, notes that the science has been considered in some detail. That's paragraph 92 and 93.
Hang on 1 second. Right. I mean, this says, which I understand, as it were, what your system is for considering science evidence within the department generally, and no doubt including for specific welfare issues about chickens. And a literature review in July 2020. But there's no reference to particular papers or other sources which have been considered on this issue. Not criticising, I just want to make clear how far it goes.
Well, we come on to that, my lord.
Oh, I see. Right.
So paragraph 90, so that explains the process. Paragraph 93 sets out the part of the conclusion, which is that the scientific studies exhibited by the claimant do not provide conclusive evidence that all fast-growing meat chickens cannot be kept without detriment to their welfare. So once we unpick the necessary double negative there.
Well, paragraph 93 is the apparent justification for the heading, but when you look at it, it's pretty specific. I mean, it says that the studies don't provide conclusive evidence that all fast-growing meat chickens cannot be kept. So the studies then are consistent, are they, with the view that they do provide strong but not conclusive evidence that most but not all fast-growing chickens cannot be kept.
No.
I mean, you could read it in that way.
Well, my lord, you could, but only if you don't look at the underlying evidence. I mean, what we're looking at here is a slightly higher incidence of particular welfare conditions in fast-growing breeds. So I'll go back to the RSPCA report because my learned friend didn't go into what it's actually saying. But what that's doing is it's saying, for example, that in one breed of chicken there might be a 2% incidence of a leg issue, and in another breed there might be a 4% incidence of a leg issue. It's not saying fast-growing breeds have this problem, slow-growing breeds don't have this problem. It's talking about the incidence of the particular problem.
And that paragraph seems to be the basis for what the judge says at paragraph 77. And again, he talks about, effectively, he's quoting paragraph 93.
Indeed, but I don't think that's certainly part of it, my lord. And then there's the list of all of the reports that have, some of the reports that have been considered, because one of the points being made below was, well, you haven't thought about this piece of evidence. You may have thought about some, but not all of the evidence. And 94, page 118, a recognition that there can be issues with fast-growing chickens. In other words, that there may be specific welfare issues that you need to be particularly alert to.
Sorry, just will you give me 1 moment? Yeah.
And then paragraph 95 that the Secretary of State does not agree as a matter of scientific judgment that the reports cited by the claimant together indicate that there is consensus in support of the proposition that it is not possible to breed and keep fast-growing meat chickens without detriment to their welfare.
Is it appropriate for the Secretary of State to treat the dispositive question as whether there is consensus? Surely it's her obligation to reach a judgment of her own.
Well, my lord, no. In
I say
the
her,
sense,
sorry, it's his now, isn't it? It was her.
but my lord, no, in this sense, that there is no decision for the Secretary of State to make here, which, as you know, is one of our fundamental problems with this claim for judicial review. Now, the judge sort of left that point and decided he should nonetheless go on and consider the merits of the arguments about paragraph 29. But in essence, there is no decision here. There's no decision of the Secretary of State that this particular breed of chicken is lawful under paragraph 29 or unlawful under paragraph 29. So when the court says, well...
But isn't that something that the Secretary of State ought to have a view on?
My
Because
lord,
otherwise, how can she issue a code of practice?
my lord, the code of practice does not specify any species, any breed of chicken. It
But our
just
question is,
refers to any
shouldn't it?
Well, my lord,
Let us suppose, contrary to what you say is the case, let us suppose that there is a that there is overwhelming evidence that one or more breeds of fast-growing chicken satisfy the Para 29 test. We need to argue about exactly what that test is at this point. By one route or another, isn't that something about which the Secretary of State should have a policy embodied primarily in the Code of Practice, but it might also be embodied in other steps she takes, like prosecution policy or trigger policy?
no, my lord, she need not. He need not. There is no requirement to adopt a policy in respect of a list of breeds of chicken, pigs, cattle, whatever it might be.
I see, just so I can spell that out. Secretary of State can, up to him or her, whether they do, say, well, Para 29 says what it says, there appears to be a breach of it, or I'm told there's a breach of it, but that can be dealt with by prosecutions.
Yes, and I need not list, and indeed one might say I could not list all of the potential breeds of farmed animal, that might breach paragraph 29, because I don't know.
No, couldn't she breach the ones? Couldn't she list the ones that she did know?
Well, she could. He could indeed, he could. But he doesn't need to. There's
Well,
no,
okay, but that,
yes.
if I may say so, it was a straw man to say you shouldn't list all the ones. I'm postulating a case where there is, you say this isn't this case, but where there is overwhelming evidence that a particular breed or specified number of breeds breach Para 29. You're saying the Secretary of State could have a policy of declaring that to the world via a code of practice, but doesn't have to, and could simply say, well, let the law take its course. The prosecutions will be brought, and by local authorities, and let's see what happens.
Or could intervene and prosecute himself.
Right, but I knew that, but I left that out because that would involve him getting involved, in which case, almost by definition, he would have a policy, because otherwise he wouldn't be prosecuting. Your point is that he can be completely hands-off about this.
Yes.
Okay.
There is, and more importantly for this claim for judicial review that's now before this court on appeal, he in fact doesn't have a list of which breeds are acceptable, which breeds are lawful.
But
that's
at a conceptual level. That's not really the point, is it?
Well, my lord,
If there isn't evidence that any particular breed breaches it, then it's quite right for him not to have a policy about it. But if there is, and it's sufficiently strong, shouldn't he? That's my point.
my lord, the challenge in this case, the claim, was that the Secretary of State had a policy of permitting fast-growing breeds.
Yeah, well, that's okay, but isn't that just another way, you say a less apt way, but another way of putting the same point? That implicit in that is that if he knows that they are doing this, or knows that they might be doing this, he ought to make up his mind and give guidance through the code of practice.
Well, my lord, I think that's right. That's how it has been suggested today, that there should be something in the code of practice specifically naming the particular breeds, Hubbard, Cobb, whatever they might be, that cannot be kept consistently with paragraph 29. That might be the case that's being put, although I have to say, it's not entirely clear that that is the case when we look at what's said about the code of practice, but I'll come on to that. But as a matter of fact, there is no, and this is all in answer to my lord's question of, is it enough to say consensus? Doesn't the Secretary of State need to formulate a considered and absolute view on this point? No, the Secretary of State is not reaching, under any statutory power, a judgment on whether a particular breed of any farmed animal is being kept contrary to paragraph 29.
Yes, you would say, I'm just spelling this out, really, if you wanted to have that, you could have a different kind of regime, which might have to say something like the Secretary of State shall review from time to time what breeds where there's reason to believe are can't be kept without prejudicing their health and welfare. And if he decides that there are any such, he shall issue a ban on the keeping of them. But you say that's not how this legislation is set up.
That's quite right.
So the Secretary of State has in fact put in quite a lot of evidence and submissions stating what his understanding of paragraph 29 and how it works is. But you say that she or he could simply have said, well, nothing to do with me. I leave it to local authorities, which I'm entitled to do because they're the people entrusted with policing this by Parliament.
My lord, in terms of prosecution, yes, that's right. The local authorities.
Say in future, in terms of what other?
I mean, people don't need a license to farm chickens or anything like that, do they?
Well, in respect of conventionally reared chickens, there's a process of registration because that allows the monitoring process. So, in a sense, I'm not sure I'd express it as a license, but yes, if you are conventionally rearing meat chicken, you need to put your hand up and say, that's what I'm doing.
Okay, but you're right, that isn't a license. That is simply a registration so that there can be monitoring.
My lord, I don't want to be held to whether that's characterised as a license or simply because it's not particularly an issue in this case. I haven't looked at it, but essentially one of the requirements that we see in Schedule 5A is the process of recording information and submitting that information because figures such as we mentioned earlier, the mortality rates. The mortality rates are not about the dead on arrival chickens, those that reach the slaughterhouse and have died in transit. But the mortality rates referred to are actually about the mortality rates on the farm. In other words, the holding has to record how many chicken are removed. Okay, well then,
but that wasn't what Regulation 15 was about. That was some other regulation which we haven't seen.
I'll come on to that.
Yes, I see. Okay.
But the simple point is, for you or I to own a fast-growing chicken, an individual chicken, no, there is no requirement that we would hold any license or permit to do so. If we were to conventionally rear, within the definition in those regulations, certain numbers of chicken and for the purposes of meat production, yes, we would have to make ourselves known to the regulators.
Yeah, but I think what my lord was getting at, certainly what I'm interested in on the back of it, is in what sense does the Secretary of State have any statutory duties in respect of the enforcement of Schedule 1, and in particular regulation, paragraph 29.
The statutory, so the only statutory duties that are relevant to what's before the court are in respect of maintaining a trigger system. And that's about the welfare triggers for meat chicken specifically.
What are those Secretary of State's responsibilities if the trigger system operates and detects a problem? What is the Secretary of State then required to do?
Well, the process requires reporting back to the holding to identify that the post-mortem inspections or the level of mortality on the farm indicates that there are poor welfare conditions on the farm.
So what happens then?
Well, then the keeper will be alerted to it, and then there's a process of inspection that follows.
Right. These are the Secretary of State's inspectors, not local authorities.
The Secretary of State's inspectors.
What have they got powers to do?
Well, there are then the other powers in the Act which would allow for ultimately closing down farm holdings or seizing animals, those sorts of measures.
And are those are keyed in specifically to Para 1. So if, as a result of monitoring, or indeed any other, presumably monitoring isn't the only way in which can trigger an inspection, but it's the main one. Suppose breaches of Para 1, any of the obligations of Para 1 are found, the Secretary of State has power to close the place down.
Well, I can go to the specific enforcement powers, but they include up to closing the holding and removing the animals from it.
Well, I think we ought to see those at some point, because I hadn't really seen this point coming. I may be making heavy weather of it. I had just taken the broad view that the Secretary of State's in charge in this area, and he ought to have a policy. You're saying he doesn't have to have a policy. All he has to do is exercise his specific powers if the circumstances provided for in the statute entitle him to do so.
But he
Possibly required, you say.
He may exercise his powers. I don't think Melinda Friend points to any duty.
All right, but there will be circumstances, as we all know in public law, where a power amounts because of the circumstances to a duty. It's irrational not to exercise the power.
But there may be, if we take prosecution as one of the heads that he identified, prosecution obviously will involve a discretion and will involve a variety of other considerations, and not just whether there's a prospect.
But prosecution is in a sense a bit of a red herring. We've had our nose rubbed in it because it's said to be relevant to the approach of construction. But the main methods of enforcement are not criminal. They are an inspection system, a monitoring system followed by an inspection system, followed by a power to do a variety of things, culminating in closing down. That's the primary system, isn't it?
Yes.
Which we haven't been shown anything about. But
well, can I just give the references?
Sorry, this is a bit unfair to you, Mr. Tony, because it's all spun off a question asked by me about consensus, and one thing led to another. Would you rather deal with it properly at a later stage, or would you rather deal with it now?
I'm happy to answer the question.
Okay, fine.
It's just to give the court the references, which is that if we're still in Ms. Thompson's first witness statement, supplementary bundle page 104, and paragraph 54 and following. Now, I'm not going to ask the court to read it now, because there is a fairly detailed explanation there about the methods.
So, sorry, which paragraphs did you say?
Paragraph 54, so it's section C, which is 54. It then goes on right the way, in fact, to the place where I started, through to paragraph 89.
Yes, I see, thank you.
And it explains how the various matters are covered by inspections. And it's a system that is fairly complicated, in the sense that there are two issues being run in parallel, which is essentially it's a food safety question as the starting point for the FSA monitoring, but then there's the inspections that are being carried out by the veterinarians, which obviously is more concerned with the question of welfare issues. And the pieces of information are being put into a system whereby reports are triggered to identify where there may be problems. And that's based on, as I say, these figures we see in the triggers, which are the mortality rates, but also whether particular features of poor welfare are present on the chickens when they are slaughtered or after they're slaughtered, in the inspection immediately after slaughter. So that's the way in which that system is being monitored.
Very well. Thank you. That's helpful. But so to come back then,
So,
my question, you answer, the Secretary of State does not have to decide for himself whether fast-growing breeds breach Para 29. He doesn't have to have a general policy about that. And all he has to do is to decide whether to exercise his powers under the supervisory regime explained by Ms. Thompson in Section C.
yes.
Thank you. I think that's really done my point to death. Subject just to one question. Could it be said, not suggesting that Ms. Thompson was intending to concede this, but if there were a consensus, that's to say, if everybody thought that fast-growing breed meat chickens could not be grown without detriment to their welfare, the Secretary of State would rationally be obliged to put a statement into the Code of Practice that was the case.
My Lord, can I break that down to 2 points?
Yeah.
First of all, the Secretary of State obviously, in public law terms, is entitled to consider the evidence, receive advice and form a conclusion on it, and that may mean rejecting bits of evidence and favouring others. But assuming consensus means everything points in the same direction, then I think it would then be said it would be irrational for the Secretary of State to nonetheless find that the breeds were capable of being kept without breach of paragraph 29. The consequent point is, does that oblige him to issue a code of practice? In my submission, no, because whether or not a code of practice is issued for any particular farming practice or any particular animal is a matter of judgment for the Secretary of State.
So I do have another question actually for you, Lord Justice Males's question to you in a moment, but just on that, I mean, that presupposes you're starting from a blank bit of paper. I mean, if there is a code of practice which is out there,
Yes.
and the scientific evidence did demonstrate that everybody accepted that you just couldn't keep breed X, the current code of practice, which is out there, would have to be changed.
My Lord, I think I accept that. To put it frankly, we're talking about 96%, I think, of the chickens that are bred for meat in the UK, some almost 1 billion animals going to slaughter a year. And the vast majority of them, overwhelming majority, are fast-growing breeds. Yeah. And so that sort of conclusion is a seismic one, because it changes, to put it one way, the way in which food is produced in the UK.
Yeah.
And so it would be, can I just say, it would be surprising if the Secretary of State in those circumstances, having reached that conclusion, didn't then take some pretty direct and significant action. But whether that's by revoking the code of practice or issuing a new code of practice, this would not be a case of fine-tuning. This would be a case of rethinking how we grow meat in the UK.
I understand that. We have no illusions about the significance, not necessarily directly of this judgment, if we're only asked to make the limited judgment we are, but of the ultimate consequences of that.
Yes.
And I can see the Secretary of State would take it very seriously.
Yes.
Sorry, I said I was going to follow on from Lord Justice Males's question, if I may, and it was the disconnect between, Lord Justice Males asked you about paragraph 93 and the evidence, and the point about that the scientific studies do not provide conclusive evidence that all fast-growing meat chickens, etc. Now, I understand that this evidence was put in at a time responding, as I understand it, to the original plea in the particulars that we've seen, that somebody did want a declaration that I think that, I can't remember what it actually said, but it was something along the lines of you can't keep any fast-growing breeds.
Yes.
But, so I understand the context in which this statement is phrased in the way it is, but the question I want to ask you is whether actually framing the question or framing the conclusion in relation to asking whether there is a conclusive evidence or a consensus that it's not possible to breed is actually approaching paragraph 29 the right way round. It's answering the point that was put, but is it actually answering paragraph 20, is it addressing the paragraph 29 question? That's the disconnect, I think Lord Justice Mills was, unless I misunderstood him, was sort of saying that phrased in the way that those paragraphs are, it's not actually addressing paragraph 29 test.
My Lord, I see that, and I apologise for answering directly Lord Justice Mail's question. I can see that sets it by the way in which it's framed, with the sort of double negative, as being setting a high threshold. But I think the positive is also...
Because the reason I asked you also, I think Lord Justice Mills was asking, sorry, he can speak to himself, sorry, but it's that you said when you introduced this evidence that it was necessarily a double negative. I think those were your words, and I just couldn't understand why you said that. I mean,
because of the way in which the statute's framed. Without...
Well, that's something I'd quite like you to give me some help if you could.
My Lord, I think this point is also put in the witness statement as can be kept without detriment, which is the simpler way to put it. And I showed the court the heading.
But it's not. But there is a material difference between those two statements. I mean, if the Secretary of State had said that the scientific, there is a scientific study which I prefer, which says that the fast-growing breed can be kept without detrimental effect on health and welfare, then that's one thing. Then he or she would be entitled to prefer that scientific evidence over studies that suggested to the contrary. But there's no suggestion anywhere, as I understand it, that any scientific study actually says affirmatively you can keep fast-growing breeds without detrimental effect on health or welfare.
Well, my Lord, if I break it down, all of the studies show for all breeds of chicken, fast-growing or slow-growing, that there will be incidents of welfare issues.
Yeah.
So that's the same for all chickens.
Yes.
So far as my learned friend puts his absolute proposition, 0.000%, that would proscribe every chicken, and I dare say every animal, under paragraph 29. As I said, what the studies show is that in the systems that are used for the keeping of fast-growing breeds, in the conventional rearing systems that are used, there are higher incidents of some particular welfare issues than in other breeds in other systems. And the evidence that the Secretary of State refers to, in particular paragraph 96 of the Thompson statement, is pointing towards the environmental conditions as being one of the key drivers in affecting the instance of those particular problems. So, in other words, that it's not the breed that's the problem, it's the environment that's the problem.
And yet, if the environment is the same for, oh, I see, because you don't have really controls, you will never have slower growing chickens, faster growing chickens kept in the same environment.
Well, you may, but none of. But
at the same time.
One of the limitations is, of course, it's very difficult to control for these things, because if you put a fast-growing chicken into the environment that you have made perfect for slow-growing chickens, it will be inapt for that bird. Vice versa, if you did the same the other way around, it would also be problematic for that bird.
So I understand that there are certain environmental factors that will affect both fast-growing chickens and slow-growing chickens. Heat, for example, might have a slightly differential effect, but it'll affect both. So you have to make sure you don't overheat chickens generally. It's not what this case is about. This case, as I understand it, is about the certain types of breed which have certain genetic characteristics.
Yes.
I.e. large muscle mass, very underdeveloped legs to support it is the one that we've all been talking about, but there are others, the respiratory system and the system to support that body mass. Asking the question the way that paragraphs 93 and 95 are phrased doesn't actually address paragraph 29, does it? Not only is it putting in potentially a requirement for conclusive evidence in relation to all breeds, see paragraph 93, but it's saying we won't, it's not possible to breach paragraph 29 unless there is a complete consensus amongst scientific opinion that you can't do it. And that's not what just not what paragraph 29 is about. This evidence just doesn't seem to be addressing. I'm not directly criticising it, but it just doesn't seem to be addressing the paragraph 29 test. It's addressing the argument that you were facing at the time.
I think that's that. It's responding to the case that was put against us, which was that there was consensus that these animals cannot be kept without detriment to their welfare. And the answer to that was no, there is not.
Yeah.
That was the case, the fact that was said to underpin the argument.
But you're not suggesting that on the basis simply of this evidence, assuming that this evidence was accepted as stated, everything is necessarily hunky-dory with compliance with paragraph 29.
Well, my lord, I accept that language alone can't answer.
In a sense, what this is demonstrating is the wisdom of the approach, or at least the prudence of the approach being taken by the appellants, which is now being taken, which is really just to get a ruling on the meaning of para 29, addressing the key points where there appears to be a difference in your approach to the Secretary of State, and to leave all the rest till later.
My lord, I think that, to cut to the chase, that is all that they can ask for, because, as you know, they say we don't challenge the Secretary of State's findings on the evidence. They accept that the Secretary of State is entitled lawfully to conclude.
Well, they are not challenging for the purpose of these proceedings, I think would be. It doesn't matter.
Well, in a sense, that they did challenge for the purpose of these proceedings, and in the High Court, they accepted orally that they couldn't challenge. So they did challenge the Secretary of State's finding on rationality grounds, and in the High Court, they accepted, as you see in the judgment below, they accepted that they couldn't impugn those findings which the judge records. And that, of course, was necessary because in public law terms, it would be a very high bar to say the Secretary of State, having considered all this evidence, could only have come to one conclusion on it. Rightly, the appellant recognised below that they couldn't make that submission, and they abandoned it. So we're left with a position where, in these proceedings, the Secretary of State's position is to be regarded as lawful, unimpugned, in respect of the evidence about meat chicken welfare. And whilst one can readily see why the appellant nonetheless says...
Okay, that's a little bit ambiguous, isn't it? Because let us we haven't actually looked at all these passages, so I imagine we've looked at the key ones. Their helpfulness to the Secretary of State depends on them asking the right question. So the question about what sort of conditions are to be assumed, and the question about what degree of detriment, whether to the whole population or only to some, are questions of principle,
Yes.
which is what we've been asked to decide. And if we decide them in a way contrary to the way in which the Secretary of State has understood them, it's back to the drawing board. And he may then, we don't know, reach a different conclusion. He may then reach a different conclusion. But that's all for another day.
My Lord, I think I take that in two parts. One, yes, on the more extreme analysis that's put forward by my learned friend, a different conclusion would be reached, because clearly when he says it could be a fraction of 1% incidence of a particular problem, well, we all know.
But in a sense, the figures you were putting forward to us test that very nicely. It may all be more complicated than this, but
yes.
you were, in headline terms, you were saying instead of leg problems being 2% of slow-growing chickens, they are 4% in fast-growing chickens. Now, they may not be exactly right. I'm not holding you to them. But if it's of that magnitude, there may well be, I don't know, you have to tell me, there may well be an argument that doesn't engage para 29.
Yes.
But we'll have to deal with the principle, and then it'll have to be applied to the facts of this case if the Secretary of State makes decisions which are thought to be unlawful even on the correct self-direction.
So, my Lord, I think that's the further point I would say. If the Secretary of State makes decisions, because judicial review is not an abstract process by which we can come to the bench and ask for an opinion on the meaning of statutory provisions, but rather has to be focused on a decision. And a decision can include inaction. So it could be relevant in some circumstances, say failing to take a decision is enough to have a decision under challenge. The real difficulty, and I'll come on to this in submissions on the declaration, the real difficulty with the way that Mr. Brown now puts the case is that he says, well, I don't need to worry about whether the Secretary of State has taken any view on anything, because I can ask the court to just opine on the meaning of these provisions. And I say, no, that's inappropriate.
I see the force, I sort of see the force of that, but couldn't, it's a long time since I've looked at these very basic points, was there never a jurisdiction in the administrative court to deal with what in Chancery Division, I think, is called a construction summons?
There is some learning about seeking an advisory declaration, but you still need to identify a decision under challenge to bring yourself within Part 54 of the Civil Procedure Rules.
Well, you have a code of practice that's been published.
Well, my Lord, so the procedural points that Sir Ross Cranston was willing to put to one side because he was going to dismiss the claim on other grounds were points that were, well, if you're challenging the code of practice, you're 3 years late. If you're
There is no respondent's notice here, by the way.
My Lord?
There isn't a respondent's notice.
No, we've dealt with these points in the skeleton.
I'm sorry not to have them in mind.
If I could take the court to paragraph 35 of the skeleton.
It's interesting, have we got I'm not saying it's a disciplinary, I just want to make sure I got the up-to-date version. Did you file a replacement certain argument?
But just yesterday, yes.
That doesn't seem to have reached me. You haven't got a spare copy there, have you?
We do have.
Did you get one?
I think I got it electronically. Right. I know I've got it.
It's quite useful to have them loose. So it's not to have to go to the bundle all the time. Thank you.
I take it the same as the one in the bundle, except it's got some references in it. Is that right?
Yes. I can't guarantee they haven't put out the page numbers, but
It'll probably slightly change the page numbers, yes. Okay, which paragraph?
paragraph 35 on my version, page 13. So what we say there is effectively, well, this isn't good enough. But I think most importantly, the last part of that paragraph it's also relevant to the question of relief.
Well, yes, all right, but there's a double question here. If by relief you mean should there be a formal declaration, or still some order to ask them to order in the Secretary of State to do something, would be very unusual. That's one thing. But the real question is whether there should be a substantive ruling of some sort on the meaning. On that, the judge decided that he would do that.
Yes.
And there's no respondent's notice saying he wasn't entitled
to say, no, precisely. My lord, that's what I said. And to that extent, I accept the proposition.
So really, although it's been very interesting and may have some knock-on effects, the argument that there's nothing here to judicially review because there is no decision isn't one that's open to you on this appeal, is it? We should be prepared to rule, at least on the matters that the judge ruled on, whether there's a decision or not.
Well, my lord, to take it through the hoops, this court should only deal with the question of whether the order should stand below. In other words, was the judge correct to dismiss the claim for judicial review? And if not, and if the claim for judicial review is to be allowed, what relief is to be granted? And what relief is to be granted? And therefore, I do say that those things are at large in terms of the appellate jurisdiction.
Well, I'm sure they are in terms of relief. We might say no relief for all sorts of reasons. But the fact is there would be a ruling by us on what paragraph 29 meant. If we allowed the appeal, we would by definition be saying the judge was wrong. We'd have to be saying what we said he should have said.
Yes. But
what are we really arguing about here?
Well, my lord, in terms of the exchange we're currently having, the point simply is, and why I go back to there being no decision.
No decision. Yeah.
Is that the Secretary of State has not made a decision on these matters. That the court is left with a hollow question, which is what do these provisions mean in the abstract? If my learned friend is going to say, well, the factual matrix is relevant to that determination, then I'd want the court to properly understand the factual matrix, which is not the way in which it's presented by the claimant.
Yeah.
And if, on the other hand, we're simply dealing with the language of the section, then I don't need to go any further into the factual matrix, save to emphasise that even if the court disagrees with Sir Ross Cranston on some of his analysis about what the provision means, it doesn't follow that the Secretary of State's fallen into any legal error.
Sorry, just to reiterate my question, I mean, I understand you say that the Secretary of State hasn't made a decision on which breeds can or can't be kept, for example. But if there is a code of practice which has been promulgated,
yes.
If that's been drafted on a misunderstanding or misreading of paragraph 29, and it contains either an error or an omission or something which is misleading, why can that not be judicially reviewed?
Well, the claim would have had to have been made within 3 months of the publication of the code of practice, as opposed to being made some 3 years after it was published.
Okay, but that point you're too late on that point. Because you took that point below. Judge decided to go ahead and decide the substantive point. In fact, he decided in your favour. It's neither here nor there.
Well, my lord, he decided the substantive point being the debate over the meaning of paragraph 29.
Yes.
But are you saying that, therefore, if this court came to the conclusion that paragraph 29 meant what the appellants say it means, and that the code of practice is wrong, we can't do anything about it?
Well, my lord, I'm not sure I go that far, but I think I'm putting the point in between, which is this, that even if the claimant's, the appellant's interpretation of paragraph 29 is right, it doesn't follow that the code of practice is unlawful.
No. Well, what I think I put to Mr. Brown, and he, I think, was content with, was that if we found that the construction of paragraph 29 was as he contended, and therefore the construction found by the judge and argued for by you in these proceedings was wrong, it would be right for us to say, I think, as I say, in a single paragraph, or at any rate, not inappropriate for us to say, Secretary of State should now go back and consider whether she, in the light of this, she wishes to change the code of practice. You'd be content with that. Is it code of practice or is it code of something or other? But yes.
I think, well, I think I'd have to take instructions on sort of form of relief, but in the sense...
Well, that wouldn't be relief at all. That would simply be a statement.
In the sense that the court may say that, given this important finding on the meaning of paragraph 29, the code of practice and other things may need to be revisited.
Yes, well, that's really what I was...
Yes.
Yeah, well, I don't want to push you into making something without, as a concession without instructions. No, that, I think, it may be that we'll be being asked to do more than that. But subject to your instructions, that would be consistent with the submissions you've so far made.
It would, but I have...
We could, if we went further, it would have to be really on the basis put forward by my Lord, and it might be prudent for you, I think, to at least address us on these to the extent that Mr. Brown did, that there are passages in the Code of Practice which either are wrong if the construction is as he says it, or at least are misleading.
My Lord, I'll come up precisely. I will answer that point when I come to.
Well, sorry, that's been a long session, but I think we have actually got somewhere. But we'd better let you get back. You were trying to go through Patricia Thompson's statement.
I think I've shown the court all I need to from there, so
yes.
I can move on. Can I just then briefly turn up the RSPCA report because it's sort of the high watermark of the appellant's evidential case. So it starts at 155 in the supplementary. Can I just make this point, and I made the point below, that the report that you have at 155 is a piece of advocacy rather than a scientific report. It is arguing for a particular policy position and extracting from a scientific report. And it may be that doesn't much matter for present purposes, but the Secretary of State's position is that the RSPCA report is not a scientific analysis, it is a piece of advocacy based on scientific reports. The scientific report it is largely based on is in fact also in the bundle at 191, an article by Dixon called Slow and Steady Wins the Race, and so the court has that. I just want to briefly, and I'll do it through the RSPCA report itself just for ease of reference, but I just want to briefly explain that the set of health and welfare indicators that were considered across 3 breeds of fast-growing
Which are identified, yeah.
And 1 slow or slower growing breed.
So,
and this may, in some of the charts, this is a bit difficult because my version at least is in black and white, and I think colours were ascribed to them. But it may be helpful just to understand that in a large number of the indicators, what we see is that there are differences between the slower growing breeds and other breeds, but the fast growing breeds have differences between themselves. And I think, to use the example of walking ability, which is page 173, the report explains walking ability gait scoring is a method used to assess walking ability, and there's a score from 0 to 5.
sorry, which are we on? Figure?
Page 173.
Figure 7 or figure 6?
It's figure 6. Well, I think it's figure 6 and figure 7. The two have to be considered together. So the first one is figure 6 is the proportion of birds that were culled throughout the trial, which had those particular gait scores. So these are ones which which had to be covered during the course of the trial. And then there's a total figure for the end of the trial when they hit a particular weight. And what the court will see is that under those measures, there is for all breeds, there are implications of gait. It's not the case that the slow-growing breeds all have normal gait, and that the fast-growing breeds all have a gait score above 0. But one sees, for instance, that if you look at Figure 6, for example, which is the culled birds, a higher percentage of the slow-growing breed have high gait scores than of breeds.
So say it again. Sorry.
A higher percentage of slow-growing breed had the higher gait scores than in the breed C.
Yes.
So what
for all we know, we don't really know what the absolute numbers are, so we've no idea whether for breed C it's statistically significant.
Well, we have that in the report. I went there because the report is heavy going. But if we go to page 198 of the bundle, so this is in Dixon itself.
I'd rather look at that.
So 198 is the results. And the gait scores are at the bottom of page 199.
Well, that doesn't tell you very much. Or at any rate, if you have to understand it better than we can do now. What are 1, 2, 3, 4, 5?
This is you picked on, of course, the one that does demonstrate that you've got a slow-growing breed that actually does less well than fast-growing breed C. I think this is the one table maybe that shows that similar situation. Maybe there are others, I don't know, but this is picked up somewhere in the evidence, isn't it? Well, there's a commentary on. There's an explanation for this in the evidence. But if your only point is that fast-growing breeds vary as between themselves, do we need to go any further than just looking at the table? Otherwise, we're going to have to get into this.
Well, my lord, it's simply that. So, my learned friend's submission today is his sort of 0 point however many noughts instance. The simple point to make is that all of the indicators of poor welfare, all of them, are also present to some extent in slow-growing breeds.
But that doesn't surprise me and isn't by itself the problem, is it?
Yeah, I mean, if you're a slow-growing chicken with a broken leg, you're going to be suffering in health and welfare terms. The question is, if you're a fast-growing chicken with a broken leg, it may well be caused because you are a fast-growing chicken.
My lord, this is the difficulty. There isn't a single, let's put it this way around, there isn't a single welfare condition that is present in fast-growing breeds, but absent in slow-growing breeds.
Yeah.
Right. So there is no feature of fast-growing breeds that is unique to those breeds, such that you can say, well, because of them being that breed, they have that problem. So you can't pick an individual chicken because you will find an individual chicken from a slow-growing breed that also has that problem. So foot-pad dermatitis is a problem for chickens, slow-growing or fast-growing. In intensive systems, it is a particular issue that has to be carefully managed. And therefore, in some of the measures, there's a higher instance of it in fast-growing breeds. But this is the central point, that the way in which my learned friend puts the evidence is to suggest that this points to, as he put it, particular and unavoidable health consequences or welfare consequences for fast-growing breeds. And that's simply wrong. There
I
might
take
be
your point about breed C on this particular test as compared with a slow-growing chicken and has a better outcome. But looking at it overall, I think it was said that it's a difference between 4% of fast-growing chickens which have these problems as compared with 2% of slow-growing chickens. Now, you might say, well, that's only 2%, that doesn't sound very significant. Or you might say, if you extrapolate that, well, that's 20,000 birds a year. Sounds like a bigger number. And twice as many fast-growing chickens have this problem as slow-growing chickens. Now you can use the 4% and 2% figures in all sorts of ways, I suppose.
But Mr. Brown would say it doesn't matter whether it's 2% or 4%, because if there's anything that you can point to with this breed, that means it's going to have.
Yeah, but the difference would be this, wouldn't it? What he would have to say, and luckily we're not going to have to decide any of these points. This is all merely illustrative. He might say 2% is the baseline that occurs to chickens generally, because there can be idiopathic reasons why a particular chicken may be lame or have an accident or whatever it might be. And what's significant, and the difference between the 2% and the 4% can be reliably inferred to be because they are fast-growing, i.e. they could be due to the breed rather than to the vicissitudes of life. Again, we don't have to form any view about that, but if you were trying to reductio ad absurdum and saying, well, if he's right, you can't even keep slow-growing chickens as they have 1%, that's not a good point, but perhaps you...
Well, my lord, in my submission, it is a good point, because he doesn't suggest that the measure is some comparative measure or what the comparator would be. What he says is that if there is any genetic or characteristic, phenotypical characteristic that arises from the particular breed, that means that it may encounter a welfare or health problem, then that's enough to proscribe it.
Well, it's got to be peculiar to the breed. And if what is peculiar to the breed is a significantly higher incidence of a particular kind of injury or symptom than would occur for other breeds, you could say that is evidence that that higher incidence or higher vulnerability is peculiar to the breed. Whereas for the breed with the lower growing incidence, you could say, well, that's not that, that's just life. That's just birds fall over sometimes.
But, my lord, that necessitates a comparative exercise which is obviously not what's on the face of the statute. And also it begs the question, because what is, so say the occurrence of a tumour in a particular farmed animal, what's to say that 1% of farmed pigs could have a tumour, but if you have a breed that has 2% instance of tumours, then that is a breach of paragraph 29.
Well, you wouldn't say that. First thing you'd have to do is you'd have to say, and this may or may not stand up on the science, that the extra 1%, or to put it another way, the doubling of the risk,
yes,
is due to the breed.
Yes, precisely.
If you said that, then that might be a breach of paragraph 29. Why is that such a terrible solution if that's what, as a matter of science, you conclude?
Well, my lord, to take the point one stage further, if there was a breed of pig that had been bred to have a 0.5% risk of a tumour, would that then, at that point, proscribe those others that had a 1% risk of the tumour, simply because you could show that there was a breed of animal that had half the risk of the tumour?
I agree, you do get into very deep questions as to the extent to which health conditions are genetic, and what's a genetic vulnerability as opposed to an actual, and so on.
But I'm accepting in that it's genetic. This is,
Right.
the reason I use a tumour is because perhaps that's one of the things it's easier to see how the genetics can play out. We all know that you can identify genetic predisposition to certain cancers. It's easy to identify that as a genetic, there may be a genetic cause. If you can show there's a genetic cause, the fact that you're keeping a breed of pigs that has a 2% risk of developing that particular illness versus a 1%, why should you proscribe the keeping of the 2%?
Well, sorry, I don't think it can't be an answer that, for example, broken legs are found in all chickens, or all breeds of chicken to a greater or lesser extent, which I think is what you're essentially saying. Suppose you have two breeds of chicken. One is genetically engineered to produce really big, strong legs.
Yes.
Tiny breasts. Okay.
Yeah.
Not very commercial, we are currently told, because everybody wants chicken breasts, we are told. That's the chicken. But those animals don't get, save in wholly exceptional circumstances, broken legs. They run around really happily.
Yes.
But you have another genetically engineered breed that is genetically engineered to have really big breasts and really tiny legs.
Yes.
And because of the weight, very few of them survive the term without breaking legs. If you're looking at paragraph 29, you'd say, if we're just thinking about broken legs and the detriment to a chicken having a broken leg, I can't reasonably expect on the basis of that on the basis of that genotype, that I'll be able to keep the small leg chickens without any detrimental effect on their health or welfare, because a very high proportion have broken legs and they suffer.
My Lord,
But I could reasonably expect, on the basis of the genotype, to be able to keep the very strong leg chickens, because save in an exceptional circumstance, you never say never. Kicking the football around, one of them breaks a leg. There's no broken leg. Well, so it just can't be an answer to paragraph 29 to say, well, you find broken legs to some greater or lesser extent in every breed.
well, my Lord, so I accept the basic proposition that you would come to the conclusion if you did have a breed of animal, farmed animal, that had some huge likelihood of suffering an adverse welfare consequence, such that you knew that just by having that breed, just by having the particular code name of that particular breed of pig or cow or chicken, that you were taking on an animal that was going to suffer, then that is precisely what paragraph 29 is dealing with.
Yeah.
What it's not dealing with is a relativistic thing where you say, well, hang on, there are breeds of chicken that have a lower incidence of these particular indicators of poor welfare, and therefore it follows that anything with a higher incidence is to be proscribed. Because if you do that,
No, I thought you were putting the equally caricatured proposition that just because you could find, I think you actually said the problems are present to a greater or lesser extent with all breeds of chicken, whether they're fast
Yes.
or slow grown. Therefore, you would essentially suggesting you can't get anything from this study.
my Lord,
And that seemed to me to be too extreme a position, in the same way as you suggest that.
my Lord, the point I'm putting on the study is simply to observe that the breed which the claimant says can lawfully be kept also has foot pad dermatitis.
Well, I think we mustn't get too, it's been helpful up to this point, we mustn't get too high, because it's now, I think, everyone is proceeding on the assumption, we're not going to express any views about what these studies show in relation to a breach of paragraph 29. We're simply doing this helpfully, I think, as an illustration of what the implications of answering the questions we are posed about the construction of 29 would be in a particular real life situation. And of course, there could be others which are nothing like this at all.
I'll go to the. I'm sorry.
Well, perhaps just one thing before we leave this, since we're in this area. Mr. Brown advanced the, as you say, very extreme proposition that even if the identifiable genetic risk of a condition that would affect health or welfare was incredibly low, 0.1% or whatever, that was nevertheless caught by Para 29. And I put to him that as a fallback, we'd have to be looking at some sort of concept like substantiality or significance, so that ignore any sort of comparative question for the moment and simply say that because of the genetic condition, there was 1 in a million individuals in the breed who would suffer. That would perhaps be called by de minimis. But there would come a point at which you would have to say, look, this is affecting 10% of the breed, 20% of the breed, and really that engages Para 29. You would say that the breed cannot be kept without damage to their health and welfare. I'm bound to say it's hard to see in Para 29 any substantiality test as such, unless that's the opposite of de minimis, which is fine. I mean, if you're just using, but a substantiality test of a different kind, something higher than higher than not de minimis, it's a bit difficult to find there, isn't it?
Well, my lord, I agree. There isn't that test, and in my submission, that's an indicator that Mr. Brown's construction is wrong. And I think
Well, what would your construction be? Would it be that every individual in the breed had to be suffering for their health and welfare?
No.
Or you have to say it was some characteristic of the breed, which would mean that most of them did? I just don't know. You tell me.
But if you were to meet the needs of the animal as best you could, it would nonetheless suffer because of its breed, because of its genetics.
If you were to do what, sorry?
If you meet the needs.
What do you mean by meet the needs?
Well, that's the legislative requirement, that you meet the needs of that particular animal. So you meet them as far as you can.
Where's the legislative requirement? There's none in Para 29, is there?
Well, look, I was going to go through the legislation.
Come back to it when you've done that.
But in essence, it's Section 9 of the 2006 Act.
Sorry, just to finish your sentence there, if you meet the needs of the animal as best you can, then...
But nonetheless, there is nothing that can be done, more that can be done to meet the welfare, to ensure that they have an existence where their health and welfare is satisfactory. At that point, you simply shouldn't keep that animal at all for farming purposes. This is what I will say is that this paragraph 29(6) has the backstop once you've taken all the other steps that are required to protect the welfare of farmed animals. Because there may be, with the way in which breeding goes, with genetic selection and the possibility of modification and so on, there may be a point where you prioritise productivity to such a degree that you're causing inevitable welfare harm. So I think
you make the point that there is no baseline in paragraph 29. Does that come to something like this? If we stick with the example of the 4% for the fast growing and the 2% for the slow growing, and assume that's a scientifically shown fact, that's distinct from something you might quarrel with, that Mr. Brown can then say, well, because it's 4% rather than 2%, that shows that the problems are attributable to the genetic makeup, and therefore paragraph 29 kicks in and is prohibited. But once he has then succeeded in getting the keeping of fast-growing chickens banned, he can actually come back and say, well, actually, 2% is pretty bad too, and therefore we must ban the slow-growing breeds. And you say, because that logic seems to follow, it can't have been intended, and therefore there must be some flaw in Mr. Brown's approach. Is that broadly what you're
Well, I do say
saying?
that. Yes, I do say that. I think I go a step further too, which is that in the way in which he puts it, he doesn't even need to have the comparative test. He just says that if his client can show ultimately, and I should say they have not shown this in the evidence. The evidence does not show this. If they can show ultimately that there is some genetic predisposition unaffected by environmental factors that causes fast-growing breeds to have poor gait or footpad dermatitis, then that's a prohibition. That's how he puts it. And all I'm saying on the evidence is, well, we know that these are conditions that will occur in all farm chickens to a greater or lesser degree. But he says, well, I'm not worried about that because any footpad dermatitis, which can be attributed to the genetics of the breed in question, comes against the prohibition. You cannot keep that animal. And that, in my submission, is absurd. And that's why his construction has to fail. I think there are, as I see it, these are the points between us on the construction. The first one is, do you assume, in assessing paragraph 29, a particular environment for keeping the animal?
So do you assume a particular?
Do you assume a particular environment in making that assessment? And he says, well, in the case of fast-growing chickens, we know that conventionally reared chickens are subject to a load of regulations in Schedule 5A, in terms of stocking densities, in terms of all sorts of other things. And those are the conditions that you should assume in making your assessment of whether or not the breed can be kept in accordance with paragraph 29. And I say, no, that's not what paragraph 29 is asking. It's not asking for an assumption about conditions. It's asking about consideration of the animal itself rather than the conditions in which it's kept. So that's the first point.
Well, I'm just not. Perhaps you're going to elaborate the second point. It's about the animal. You've got to assume the animal in some conditions, haven't you?
Yes, well, you've got to.
I mean, an animal that was genetic animal that was an animal which, for genetic reasons, was peculiarly susceptible to cold. Wouldn't matter if all chickens were kept in warm conditions anyway.
That's why I say that the logical way to read paragraph 29 is as the backstop, having already.
Well, I understand that, but just on, you were saying that you focused on the animal itself. I didn't quite know what that meant. But all I was pointing is you've got to assume some environment.
My lord, of course, there's some environment, but it's an environment that you don't say this particular breed of chicken has to be assumed to be in this shed, in this bit of England, under these particular conditions. You say, can this breed of chicken be kept as a point of principle, as it's based on its genetics, based on its phenotype? Can it be kept without detriment? And if the answer to that is, but only if you provide it with particular heating and particular water and particular food stuff, then that is the answer. You can, but you must provide appropriate conditions.
And if you don't, the other provisions of the Act will ensure that they're not kept.
And what Mr. Brown says is, no, you should answer that question differently. You should put that chicken into the farming arrangements that are the minimum permitted under Schedule 5A, and then consider whether it can be kept in those conditions, in light of its genotype and phenotype, without detriment to its welfare. And I say that's the wrong way to look at it, that he's aligning the two things. And of course, his interpretation saying, look to Schedule 5A, only works for meat chickens, conventionally reared meat chickens, because there isn't provision in respect of the keeping of lambs, for instance.
I'm slightly struggling with that because you just introduced this section by saying that your overriding submission was going to be that paragraph 29 is the backstop to
Yes.
compliance with all the other
Yes.
conditions. So, do you not just assume that all the other minimum conditions in all the other things are met, and then ask the question?
They must be met, but they might not be all that animal requires.
Right.
So stocking density alone might not be enough to ensure that a particular breed of chicken is kept without detriment to its welfare. You may also need to feed it particularly, or give it particular medicine, or keep it at a particular temperature, because you have to meet its needs.
I'm struggling to understand the concept of a backstop then. Is it just that?
Because as the stock, you have done all you can to meet the needs of that particular animal, but nonetheless, it is suffering detriment to its health and welfare, and inevitably would do so because of how it's been bred.
Well, I see exactly how you put it, but there's got to be some limit on that. If everything you have to do to meet the needs is just completely unrealistic, take the example I had. Suppose we're talking about inability to walk. I know, say we're not talking about inability to walk. Say we're talking about inability to walk. But that can be mitigated and keep the chicken happy if it were carried around or given a little, I don't know, my example becoming sillier and sillier, but given wheels or something. Nobody's ever going to do that. And the more straightforward answer is you shouldn't be keeping it in the first place. So even if you don't accept Mr. Brown's minimum conditions, hasn't it got to be conditions of a kind which might, your concept of steps to meet the need of a kind that might realistically be taken?
Well, my lord, there is no measure of detriment to an animal or detriment to welfare. There is no singular measure. But one of the features that you've already been referred to is meeting the physiological and ethological needs of an animal. Now, if you take, for example, a chicken, chickens walking and pecking and scratching through loose material on the ground is part of the behaviour that you would expect of that animal.
Yes.
And if you had a breed that was deprived fundamentally of its ability to do that, because, for example, it didn't have fully formed legs, then that animal on that analysis might be said you can't.
Yes, I chose a bad example. It's always a problem with examples. But the mitigation, if I can call it that, which you say will make it all right, the more than minimum conditions that will meet their needs, there's got to be conditions of a kind that it might reasonably be expected would be taken.
And I think that's the word friend reminds me. It's the reasonably expected. Obviously, here is looking at the way as to whether or not the welfare of the animal is preserved, but that obviously involves some sort of real world consideration as opposed to taking a hypothetical to say, well, I could breed animals in a particular way and aid them to move around by robotics or whatever it might be. That would not, I think, meet the reasonable expectation test. If I could just turn up the Act, which is tab 3 of the Authorities Bundle.
May I just make a note of that for 1 second?
Are we still on your first point of difference between
Mr.
Brown, or have we moved on somewhere else?
I'm sorry, my lord, just get me on track.
That was a very useful exercise you were doing, even though we've done our best to stop you doing it.
Conditions is the first one. The second point is whether to phrase, as it's put by my learned friend, as a conditional permission or as a prohibition, as we put it. Now, I'm not sure, in fact, a huge amount turns on this different analysis. But the way in which my learned friend puts it is, well, all animals are prohibited from being kept unless you can show, i.e. the keeper can show, that it can be kept without detriment, etc., etc. And I say that that's the wrong way to view these sorts of provisions. Whilst linguistically, you might contend for that solution, in fact, it's a prohibition on keeping an animal where inevitably its health and welfare would be compromised. And it has to be viewed as a prohibition because otherwise, in the criminal context, it would be enough to allege that an animal was being kept, and it would then be for the keeper of the animal to have to show that the genetics and so on was consistent with welfare. In other words, it would shift the presumption away from how in my submission it's clearly intended to be. And again, in my submission, it shows that Mr. Brown has the whole provision the wrong way round, because he effectively says that the single most important provision in animal welfare, farmed animal welfare regulation, is paragraph 29, which is a prohibition on keeping unless you can show, in other words, a conditional permission to keep animals. And I say that's wrong.
I haven't quite understood why you said it. I think you've accepted linguistically that's how it's structured.
It is.
But you're saying, all right, but that's just a trick of language and perhaps has some particular drafting reason. You're saying substantially it should be what?
Substantially it should be that you are prohibited from keeping an animal if.
And what's the difference?
I'm not sure there is a huge difference.
No.
I mean, you say the difference is burden of proof in a criminal case, but I'm rather sceptical about that.
But my lord, I accept that it might depend on the way in which the criminal case was formulated, but the evidence. But I think perhaps the more important thing is that conditional permission argument discloses where Mr. Brown goes wrong, because he flips the provisions on their head. He starts with paragraph 29. You can only keep an animal if, and then there's a whole series of conditions which follow.
I haven't seen why this leads him wrong. He's only doing what the statute says. Why is that meaning he is saying it is the most important provision in the whole of the animal welfare regs?
Because he says that the keeping of animals, farmed animals, across the UK is only permitted if a regulation introduced into the regulations in 2007.
Yeah, but in 99% of cases, there'll be no question of a specific breed, of a breed-specific problem.
Not on Mr. Brown's analysis. I would venture to say in most cases there'll be a problem on Mr. Brown's analysis.
Why?
Because he says that if the genetics of an animal, I'll just use genetics rather than phenotype as well, if the genetics of an animal give it a disposition in some percentage of the individuals of that breed will have a welfare problem.
A welfare problem peculiar to that breed.
Peculiar to that breed will have a welfare problem peculiar to that breed, then that's enough to prescribe.
Yes, but I'm putting to you that is probably it's unusual for people, for animals to have, for particular breeds of pig or whatever it might be, to have welfare problems peculiar to that breed that other pigs generally don't have, but that one does.
Well, if it's said to be peculiar to that breed, in the sense that it's a welfare problem that only arises in that breed and not in others, then we shouldn't be here, because none of the welfare problems that the claimant has relied on are unique to fast-growing breeds. None of them.
Well, but that's begging the question. It may be that what's peculiar to that breed is, well, all right, there's two answers. One which you may not like, may think is wrong, is peculiar if it's vulnerability or susceptibility to a particular symptom or illness. So all pigs have have an incidence of some particular illness, but it's much higher for a particular breed, you shouldn't be keeping the breed for which it is much higher, because that is genetic. I suppose what you would say is, if it's genetic for the pigs, we only 1% of pigs have it, with 5% have it. It's also genetic for the ones where 1% have it.
Yeah.
That's the point you were making earlier.
And then, but I see my Lord's comparative exercise, but I do emphasise that that's not the exercise Mr. Brown suggests. He suggests it's an absolute exercise. So if you can point to something, some welfare detriment, because a particular animal may develop cancer. So if a breed of pig may have a 1% chance of developing cancer, he says that cannot lawfully be kept. If I've misunderstood, he's shaking his head.
Yeah, you've misunderstood, because you're failing to then give effect to the keeping aspect of this, because it is the breed, which means that if the issue manifests, the detriment arises because of the keeping. So if there is simply a 10% rate of tumours in the pigs, but that just occurs irrespective of the keeping, then that's not the mischief of paragraph 29. So it's a combination.
Well, no, if there's 10% in kept pigs, all pigs are kept. I mean, apart from ones that run wild in Forest of Dean.
As I understand the way this is being put, if the breed is found to have at birth simply a 10% rate of tumour manifesting, that's not something to do with the conditions in which the pig is kept. That is just its fate at birth, irrespective of the conditions.
Well, we better not let this become a to and fro.
I'll deal with
No, it's not your fault, because Mr. Attorney invited you, but this requires some thinking about, which I'm not sure, which I think we may have to do overnight. But,
my Lord,
but just before we leave it, the situation is different, where the symptom is one which needn't necessarily be genetic at all. You know, take a very crude example, but going back to pigs and lays, if they have gait problems, it may be because a certain percentage of them simply have accidents, or have some catch foot rot or something. So there isn't a problem where for Mr. Brown, where the increased rate is evidence of something genetic, whereas the lower rate is just life.
Well, my Lord, and this is where I think Mr. Brown's argument becomes unstuck, because he says, well, no, when I'm talking about the instance, I'm talking about in these conditions. But the instance itself must be a consequence, as he says in his own repleading, of the genotype or phenotype. So in other words, it can't be anything. The instance of the detrimental effect can't be anything itself due to the conditions.
Yeah.
And he's saying that what he says is the assessment of that is done by reference to the conditions. But he still has to trace it back to the particular genotype and phenotype. And the point here is that if you have, to use the example, a breed of pig with a 10% chance of developing a tumour, and another breed of pig with a 5% chance of developing the same tumour, which one is to be proscribed under paragraph 29? And you can establish this through genetics. Let's say you can just show through genetics there's a 10% chance with this breed it will have the tumour and 5% with this breed. Which one is to be prescribed?
Yeah. Well, it's a point you made before. Right, you are on the points between you are: one, do you assume a particular environment? That certainly is a difference. Whether you call this a proviso plus a prohibition subject to a condition or whatever, at the moment I'm not persuaded that's a real difference, but we hear what you have to say about that. Any more differences you want to identify?
Then I think it's down to this, the heart of the point, which is whether detriment means any degree of detriment in the sense that we've just been having the exchange on.
Okay, sorry. Well, can you just flesh out the rival contentions as you see them for that point?
Well,
it was a bit shorthand for me at this time of the day. Sorry.
Mr. Brown's submissions is that if you get to a point where you know that the particular breed that you've procured has a 5% chance of developing this particular condition which will have an adverse effect on its welfare, then that's enough to prevent you from keeping any individuals within that breed. That's his submission. And he goes down to below 5%, but that's his submission. Whereas my submission is that if you have regard to all the appropriate measures that you may take to ensure the welfare and detriment, can you nonetheless expect that your animals that you keep can be kept without detriment? And the fact that nonetheless 5% of them...
But then you slip back into your first point.
That's the first point. I thought that's just another way. Yeah.
Well, my lord,
Suppose the position were that your first point is met and you have done you've done all you can, all you reasonably can, and there is still a 1% chance of 1% incidence of the detriment. Is that enough? Or if you made it like 1% 16 millimetres, what about 5%?
That's it. So I've done all I can, and there remains a residual risk of welfare detriment because the animal may develop a cancer. I say that doesn't prohibit you from keeping the animal.
That doesn't.
That does not prohibit you from keeping the animal. No.
And that, because I know you. All right, yes, but just say why you say it doesn't.
Because to do so would be to prohibit the keeping of all animals. It would be absurd. Because inevitably, some of a flock will die prematurely, will develop a foot problem, will develop a heart problem or a lung problem.
But isn't the emphasis here on animals which, because of their breed, either genetic breed, somebody has bred them to have a particular genotype?
So if I have a flock of 100 sheep or 100 pigs, and I have those 100 sheep, I may know that history shows that one or two of those sheep will die before they reach slaughter, and they'll die perhaps uncomfortably because of disease. I may know that, but I can nonetheless, in those circumstances, reasonably expect that I can keep that flock of sheep without detriment to their welfare, notwithstanding the fact that there will be welfare issues along the way. Some will die, some will fall ill, and I will have to deal with that as I go along. And in my submission, that must be right, because otherwise you'd only be permitted to keep animals if you could be sure that nothing will go awry until the moment they get to the slaughterhouse.
So is your solution essentially to read in some element of materiality into paragraph 29 so that you can reasonably expect that the flock in general will be all right, and that those who have problems will not be a material number, something of...
Well, I think that's, in my submission, that's part of the reasonable expectation. Yeah. That it's necessarily, it can't be about individual animals, because there's no guarantee that any individual animal will...
Well, the other way to do it, I keep coming back to this, but the other way to do it is to have the concept of peculiar to the breed. That's really, what policy terms, what Para 29 is about. It's about breeds that are specially vulnerable because of the breed they are. Isn't that really what it's about?
My lord,
it's not
yes, but especially vulnerable to inevitable detriment. Especially vulnerable to inevitable detriment. In other words, that because of what that breed is, it will inevitably suffer. I can expect that it will suffer. Because I know that for this particular breed of sheep, 95 of my 100 flock keel over dead in the field. They will inevitably suffer.
Whatever I do.
Whatever I do, no matter how good I am as a stockman. And that's the mischief that paragraph 29 is focused on. It's not dealing with the exclusion of genetic illnesses.
Part of the problem, of course, is that the more we discover about genomes, the more you can say everything is genetic.
My Lord, precisely, and this is why these regulations were being brought into force, because what was being seen was the more and more sophisticated use of selection to guarantee farming outcomes.
And presumably, you tell me if I'm wrong, but presumably more or less all farm animals are bred to some degree in that way to produce either the best wool if it's a sheep or the best meat if it's a cow.
Have been for thousands of years.
Have been for tens of thousands of years, going back to when we first...
So there is, as it were, again, a problem of no baseline. There is no, as it were, natural animal against which one can compare these things.
You can't measure the dairy cow in Somerset against the auroch that was roaming across Somerset 4,000 years ago, because there has been a process of genetic selection for the purposes of food production. So we have to
and even the further complication, to some extent, for the purposes of welfare, not because all farmers are soft-hearted, though many of them are, but because unhappy animals are not good for you anyway, or unhealthy animals. So they're actually bred for good health as well.
Well, my Lord, yes, and I'll come on to the code of practice, but that is it. Breeding for welfare-specific traits is a major part of at least chicken breeding programs, and the British Poultry Council put in submissions which explain that, but I think it's not in dispute anyway. So that is an important part of breeding programs, and that is not an entirely unselfish exercise, because if, of course, particular welfare issues are identified, some of them may necessitate the slaughter of the animal on the farm, meaning that it can't be sold into the meat business. And the objective of the farmer is to get as many fit animals to the slaughterhouse as possible. And that means that actually the issues of productivity and welfare are not necessarily running head to head. They may well run in parallel. And I think that
not necessarily, but not always.
Necessarily.
Not always. I mean,
not necessarily always, but and I say may run in parallel, and because of the interest in making sure that fit animals that will pass inspection and therefore can go into the food chain reach the slaughterhouse, because the animals that are dead on arrival are disposed of. They don't go into the food chain, and the animals that have some particular problems may also be taken away and found to be not fit for consumption because of the instance of those particular welfare conditions. So I was going to... So those, I think, are the differences between us in one way, shape or form. I was going to go to the 2006 Act. I'm not sure how long the court would wish to continue sitting.
How are we, with both of you, but perhaps with you in particular, we've taken you off your course a bit. How much longer do you think you're going to need?
I don't think I can finish before a sensible close of play today.
Oh no, I didn't.
So I think probably another hour submissions, which would fit tomorrow morning. But equally, I'm happy to make a start.
Yeah, I think if you've reached a natural break, I mean, this is quite hard going. We won't just go on for another 10 minutes for the sake of it. Very well. Thank you. 10:30 tomorrow.
Why is it